I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we're stepping into compilation number 207. We will be in 3 different judges' courtrooms for this compilation. Before I give you those names, I just want to say thank you for so much love on the compilations and the videos. It is much appreciated. Don't forget, commentary will be left in from when these previously aired. Also, chapters will be added for your convenience. And now let me give you the rundown of the judges' courtrooms we will be in on today. First, we will be in the courtroom of Judge Kolony Phyllis out of the state of Colorado. Second, we will be in the 44th District Court out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Phyllis Webster out of the state of Kansas. I hope you guys are doing well. I hope you guys continue to enjoy these compilations. And now let's jump into 207.
This is 25M2378, People versus Alan Herrera.
Anders Erickson for the people.
Mr. Herrera, right at the podium.
All right, so he was supposed to be here earlier this morning. Can you tell me what happened?
Thought his court date with that.
Position with regards to the warrant.
No objection to quashing it, Your Honor.
So given that he did appear today, I will quash the warrant, reinstate personal recognizance bond. We need to issue a mandatory protection order because I don't think one was ever issued in this matter. Let's see. So it looks like, Mr. Erickson, you want the listed victim protection order in boxes 1, 2, and 3. Is that correct?
Yes, Judge.
All right. So, Mr. Herrera, I am required to issue a mandatory protection order in this matter. It quite frankly should have been done a long time ago, but it looks like it was an oversight on behalf of the court. So I'm going to issue it today. It will list Margaret Kirshner as the listed victim or protected party. This protection order will state that you cannot harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts that you are charged with committing. You must also vacate the home or stay away from the home of any of the listed victims or witnesses. You must also stay away from or avoid any other location where they are likely to be found. And you must refrain from contacting or directly or indirectly communicating with any of the listed victims or witnesses. Do you understand those conditions?
Your Honor, I just want to say that I'm the beneficiary of my account, and but we can proceed with this matter as director and beneficiary and executor of my own trust account. I have 21 days to show me a proof of claim of writing. They have jurisdiction to bother me at all. Until then, I do not consent to proceed. My next question is this a common law court? Because I represent myself under common law, or is this an admiralty court?
It's not an admiralty court.
And the day when the alleged allegations were created, I didn't see anybody. I was on the bike trail. Nobody was around me. So my question is, do you charge people when they are close to you, or do you charge them when they are far away? And people taking their own time to use accusations? Because this is what this ticket I'm being held here for something where I didn't see anybody. I got off the bike trail, but there was nobody around me, so there was people watching me. And to me, that's what I'm explaining about this.
So certainly, Mr. Herrera, I'm to talk with Ms. Nasri, and she can certainly answer any of those questions for you. All I'm asking at this point is whether or not you understand the conditions of that protection order. Do you understand those conditions?
Yeah, I comprehend. To stay away from the person, which I don't even know who she is. And yeah, I'll stay away and mind my business. Like I got no business. I don't even know who the person is.
Okay, so knowing that you don't know who she is, it's not going to be an issue for you. It doesn't sound like so. That's a good thing. So we'll give you a copy of this order today. You're welcome to take a copy with you if you would like. You'll need to sign it before you go. And then you'll have time to talk with Ms. Nazary further about this case, and she can certainly answer those questions that you have, okay?
And I just want to say I don't consent to the social experiment I'm going through. And that's just my situation. Everybody's case is different, but this is what I'm going through. And I believe President Donald Trump and other people been going through certain type of like harassment through different ways, you know what I mean? But all I gotta say is it's not intentional, and if I could face my accuser, then I'll try to make it right. But I'm here to show up for this. And for the record, I didn't know court was at 9:30, and I thought it was at 1, and I just rode like just trying to get here, and I'm glad I made it at least. But thank you for your time. Thank you for your consideration, everybody.
You're welcome. So let me get you a new court date. Ms. Nazary, how far out do you want to set it? I can do June 15th or June 16th.
June 16th, that one.
Okay. So Mr. Herrera, I'll set you June 16th at 1:30. If you need a reminder slip, we can get that for you before you leave today. Otherwise, just make sure you stay in touch with Ms. Nazary. I will grant the request for a Bridges liaison as well, and she can talk to you about what that means, okay?
All right. Thank you, y'all. And have a blessed day. Thank you, y'all. Shalom.
Hold on, Mr. Herrera. Ms. Nazary's going to try, we're either going to do an order or she's going to try to get the eval from the other. All right, Mr. Herrera, take care. Have a good day, okay? They'll call you up in just a second, okay? Come on up, Mr. Herrera. Great, I think that takes care of our docket. Do you all have anything else? Okay.
I just wanted to say something really quickly on this first proceeding, first time being in Judge Kolony Phil's courtroom. She handled that well. She didn't even really give it any energy or any feedback to allow him, to keep going on and on. But Mr. Alan Herrera, he definitely seems to not only want to use the sovereign citizen script, but it seems like a little bit more maybe going on with him mentally, just by, some of the giggling and some of the things that he's saying. Prayerfully, that's not the case. Hope, I would rather him be, just playing for the script than to truly be going through in his mind. But if that is the case, definitely, we'll be praying for him and hope that he, gets better and stops the whole sovereign citizen argument thing. But it could just be an act, right? You just never know. But we've had situations on this channel where we've seen people that it's just not an act. It's just not to prolong the proceedings, but it's absolutely because they're going through in their mind and they've gotten a hold of this script and they just basically added into, what they're already dealing with mentally. So we'll see how this thing plays out. But Judge Fields definitely held it down. He has a continuance. We'll try to keep up with that. Shout out to Sovereign Citizen Chronicles for sharing this with me. And now let's continue on in compilation 207.
People versus Robert Shaw.
Very good, have people.
Here by special appearance, Your Honor, remain in honor and not to argue but to challenge authority.
Your name?
Showman Robert Lewis.
Okay. This is the date and time set for a preliminary exam. Mr. Chauvin appears here on his own. As we've done in the past, Mr. Chauvin, I need to make sure you understand your rights today with regards to the potential to be represented by counsel. We've had this conversation before, correct?
I do not consent to any statutory authority presumed by this court.
Okay. We've had that conversation before about your right to have an attorney.
I am representing the all caps name, Your Honor. I am the attorney.
Okay. Do you want to have an attorney assigned to you?
No.
All right. You understand that if you wanted to, the court would have the Michigan Indigent Defense Counsel assign you.
I understand that.
Okay. You understand also the challenge, the crime that you're charged with?
Yeah, I don't understand that.
The maximum penalties? It's a felony charge of non-sufficient funds check that occurred on or about May 31st, 2024. Maximum penalty is up to 2 years in prison and a $2,000 fine or 3 times the amount payable, whichever is greater. You've heard all of those maximum penalties before?
I have.
You have any questions about that?
No.
And having heard those maximum penalties, is it your request today to proceed on your own without counsel?
Yes.
Okay. You know that I have to treat you as if you had an attorney, correct?
Yes.
Okay. You know that I can't assist you in any way as we go through this hearing. You're going to have to question witnesses on your own. You make the decision on whether or not you want to testify. You understand all that.
I do have the right to question.
You do?
Yes.
Okay, you do. But I won't be able to help you with that.
Right.
You understand that? Okay. Have you ever gone through a court hearing previously where you represented yourself?
No.
Okay. Have you looked into what a preliminary exam entails and exactly how this is going to go procedurally?
You briefly explained it to me last time we were here.
Okay. Do you have any questions right now about the process?
Well, my first question is, my question really regarding the whole thing is, I don't know if she is,
Who's she?
the prosecuting attorney is capable of even speaking in this thing.
I'm not sure exactly what you mean. My question was about preliminary exam. I'll let you can make your motion here in a moment if that's what you're getting at, but if you have any questions about this preliminary exam.
No.
Knowing all that, all the understanding and explanation that I just gave you, your decision today to proceed on your own.
Yes. Yes.
All right. You want to bring up a couple issues?
Yes, I have an issue with the fact that under the bankruptcy of the United States of America, does the prosecutor have bonded fiduciary or sworn trust? Does she act as a prosecutor with bonding and act as a trustee for the United States?
So
Is she able to do that?
Are you asking me a question?
Yes.
Okay. I'm not going to answer any questions. Do you have a motion that you want to make or challenging something? And
Yes,
saying
I'd like
that the court should move in one direction or another. I'll make a decision on that.
I would like to make a motion to challenge the validity of the prosecutor being able to prosecute this venue.
Based on what? I'll give you a chance. Based on what?
Based on the bankruptcy of the United States of America.
Okay.
Because is she a trustee for the United States of America? That is my motion.
All right. Ms. Lee?
Thank you, Your Honor. Your Honor, I'm a licensed attorney in the state of Michigan. I am employed by the county of Oakland, and I have authority to exercise my prosecutorial duties within any district court within the county of Oakland. Furthermore, Your Honor, this charge is not anything that has been charged federally. Otherwise, there would be a federal prosecutor here. This is a county level from the city of Berkeley. So yes, I do have authority to move forward with these charges because the charges did come from my office, which is at the state level.
All right, and I've reviewed the complaint prior to today's hearing. It complies with the Michigan court rules and the statutes that are at issue. Mr. Chauvin, you've made an objection. It's been being recorded on the record. The court's denying your objection, denying your motion. Have another motion you want to make? Are we ready to go?
Yes, I also have a motion for denial of process that this should not even be taking place because I was denied access to documents, records, by making me pay for a fee for copies, which is against the Constitution.
What copies did you have to pay for?
Copy of records,
Which records?
my court filings.
Your court filings?
Yeah, that I submitted.
You needed copies of the documents that you submitted?
Yes, certified copies.
Did you get those?
I had to pay for them.
Okay.
There should be a judicial notice, I guess.
I have something here. With me, did you get anything?
I did not, Your Honor.
Did you want to review this?
May I approach, Your Honor?
Any response to what he's talking about?
Your Honor, I mean, with regard to getting certified copies, everybody has to pay for those, so I'm not entirely sure where the issue lies. Furthermore, they're his documents, so I'm not entirely sure why copies were needed to begin with. So I also have nothing to do with whatever fees are issued by the court.
Sure. So those fees are again set by court rule and statute, and you know, your objection to the court imposing those fines, or not fines, but fees to get the copies, those are overruled. The court's just following the court rules with regards to that. Your motion is denied with regards to the impact it may have on your due process. If it did have an impact, it would be a negligible one, given the fact that they were the documents that you had submitted. And the court register of actions would just simply confirm that they were actually submitted, which you could have also done by bringing your own second copy, having a true copy made, or a stamped copy returned to you that way. But in any event, I don't believe it has any impact on the way that we're going to proceed today. So again, you made your motion. There's a record of it. I denied it, and we're going to move on from there. So, do you have any additional motions?
Yes, I have one more motion. I think that this case should be totally thrown out because there was no legitimate warrant, sir.
No legitimate what?
Warrant.
Oh, warrant. Okay.
Which is why we're here in the first place.
No legitimate warrant.
No lawful warrant. I apologize.
Before I let you respond, what are your objections to the warrant that they would make it unlawful?
Well, I wasn't notified of a hearing to have the warrant issued, and under law, Public Act 1957, I'm allowed to be at a hearing where a warrant is issued in my name.
Were you denied access to the hearing?
I've never received a notice.
Okay. All right. They
Your Honor, the warrant was issued by the office. It was sworn to by the court, entered into the system. I believe that there is not only case law, but statute, Michigan law, that allows for that to occur without having the person being charged present.
I agree. I'm going to again deny your motion. You've made a record of it though, and that's the court's ruling. So any additional?
No.
All right. Then everyone can have a seat. And did you want to call your anything from you?
Yes, Your Honor. I would just ask for a mutual sequestration. I'm not sure who this individual in the court is.
Okay. Were you? Who's in the court?
This is my wife.
Okay. Is she a potential witness in the case?
Your Honor, is this Kimberly Chauvin?
Yes.
She's listed on here as a witness, so I'd ask that she be sequestered as well.
Okay. Any comments about that request?
She kind of helped me with counsel though, so.
Okay. She can't do that. She's not. Is she an attorney?
No.
Okay. So she can't do that. So that's not a basis for me to deny the request. So the reason that we'll have everybody step out on both sides, so any of your witnesses except for the officer in charge would also need to be out in the hallway, is that all the testimony will then occur and then we'll be able to hear it and have that influence the way that they're going to testify. So on that basis, the motion to sequester witnesses is granted. So Ms. Chauvin, you'll need to step out in the hallway and we'll get you when it's your turn to come to testify. Okay? All right. Your first witness.
Thank you, Your Honor. People call Matthew McBride.
Just wanted to stop really quickly right here, guys. As we can see from Mr. Chauvin, it's not really going all that well. Some of the similar arguments that we always hear, but I think it may be about to get worse because now we're getting ready to hear some witness testimony from some of the employees of that credit union. So without further ado, guys, let's go ahead and jump back into the proceeding.
All right, so before you get seated, if you please raise your right hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth. I do. Put your hand down and have a seat. Once you do get seated, if you state your first and last name and provide the spelling of both for the record. Sorry. Jeez. Can I break this? Sorry. Tony's.
Sorry. Matthew McBride, MATTHEW
Go ahead and say you.
Thank you, Your Honor. Mr. McBride, where are you employed?
Credit Union 1 in Berkeley.
And what is your job?
I'm a teller.
I'm gonna draw your attention to May 31st of 2024. Were you working that day?
Yes.
And are you familiar with a Robert Chauvin? Did you
Yes.
see him in the courtroom here today?
Yes.
Can you please point to him and identify something he's wearing?
I guess a pale shirt.
Thank you. Your Honor, let the record reflect that the witness has identified the defendant. I'm showing you what's been marked as People's Exhibit 1. Please take a look at that. And is that a copy of the check that was provided to you on that date?
Yes.
Did he also provide a copy of his ID?
Yes.
And once he provided copies of the check and his ID, what happened next?
So he did, or I handled deposit and then he wanted to do multiple cash withdrawals.
And did you provide the withdrawals to him?
Yes.
And how were they provided to him?
In envelopes, like
Okay.
different denominations.
Okay.
Usually ask for certain amounts in separate envelopes, so
And it was cash.
yes.
So the check that was provided to you, what was the amount on that?
It's 30,000.
30,000. Okay. And how many withdrawals were made?
7.
Okay. And what were the amounts of the withdrawals?
So one for $1,024, $960, 1,500, 600, 1,200, and 2,000.
Mr. Chauvin, you have the opportunity to cross-examine this witness.
I have no questions.
All right.
Your Honor, people call Jillian Taylor.
Ms. Taylor, before you get seated, if you'd raise your right hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes. Ms. Taylor, where are you employed?
Credit Union 1.
And is that in the city of Berkeley?
I used to be the manager in Berkeley. I'm now at St. Clair Shores, but I was, yes.
I'm going to draw your attention to September 5th. Did you contact, of 2024, did you contact Berkeley PD?
Yes.
Why did you do that?
Our risk management department sent over a packet to send down to them. So when they do that, they just send it to the branch manager, we call and hand that over. It was, from my understanding, it was because bad checks had been passed and was causing us a loss. So they were sending that down.
And the person who had deposited those checks, were they notified to your knowledge?
I believe so, yes.
Objection, Your Honor, that's hearsay.
Did you provide a packet from your loss prevention to Berkeley PD?
Yes.
So you gathered everything up and gave it to them?
They gathered everything up. So they send me the packet complete. I don't actually.
So you just, okay.
Yes, I just handed it over.
Okay, thank you. Your Honor.
All right, Mr. Chauvin.
Your Honor, I have nothing further to say.
Mr. Chauvin, any questions for the detective?
Yes. Sorry. On the date we spoke on the phone, did you have any intent, or did you think I had any intent to fraud the bank?
Objection, Your Honor, calls for speculation.
Same.
All right, I have no more questions.
Lisa.
No, you're correct.
Mr. Chauvin, do you have any witnesses you are calling today?
No.
All right. Will you be testifying? And as to bind over?
Your Honor, people will provide over charges of any argument for them.
Mr. Chauvin, any comments about bind over?
Yes. So to bind over is to go to circuit court, correct?
Correct.
Okay, so I do have one question though. In my attempt to cure debt, I attempted to deposit a bill of exchange, which is lawful, and they rejected it. So why is that not taken into consideration here?
Okay, so your argument is that you tried to cure the debt, and so for those reasons, the case should not be bound over.
Yes.
Okay.
Your Honor, I would just indicate for the record, you did the testimony that the bill of exchange that was presented by Mr. Chauvin was indicated to be not accepted as tendered legally to the bank. Furthermore, Your Honor, that's a question of fact for the trier of fact.
All right. The court's heard the testimony from the witnesses today, the arguments of the parties. I find that the testimony provided by the two witnesses from the bank and the detective do meet the probable cause standard required at the preliminary exam to bind over this matter to the circuit court. Mr. Chauvin brought up a potential trial defense. That's an argument that you could make later on down the line. But as of today, that is a question of fact and whether or not that was an actual legal tender that you had provided. And it's not a basis to deny the bind over. So that's something that we'll continue to move on down the line here. I find that the testimony met the burden. So count one is bound over to circuit court for further proceedings and bond is continued.
Well, guys, we've come to the end of this proceeding. And as we all knew as this proceeding was going along, that it wasn't going to work out well for Mr. Chauvin. And then after the testimony of the teller and the former manager, it definitely put a nail in his casket. You know, he started out trying to get the case thrown out. One, he said the prosecutor didn't have the right to prosecute. That motion was denied. Then he wanted the whole case dismissed. That motion was denied. He talked about securing the debt with an ability of exchange. That was denied. So everything he pretty much tried in this proceeding with him, you know, bringing this $30,000 fake check to the credit union and then cashing it and having all of these, leaving with all of these different deposits. It just didn't really work out well for him. And that's why the judge, with all of the evidence against him, found that, definitely there was probable cause for this to go to trial before the circuit court. And I don't think that this situation is going to get any better. I thought that his wife was going to testify when they made her leave out. I thought she would be coming back, but that didn't happen. He didn't really have any questions for the witnesses, didn't have any body to witness on his behalf. So it was a train wreck from the beginning. But with that being said, I did some digging on trying to find out when he would be in circuit court or if there was any conclusion on the matter. It was really hard to find anything. And we know that with circuit court, a lot of times they don't air a lot of their trials. But if I get any more information on Mr. Chauvin, I will definitely share it with you guys. But with that being said, guys, once again, thank you for joining me. Don't forget to like, subscribe, and share. This is Sovereign Citizens Hall of Fame, guys. And for now, Sovereign Citizens Court is adjourned. I appreciate you guys. Talk to you soon. God bless.
We are on the record in the 13th Judicial District Court of Greenwood County, Kansas. This matter comes on for review in 2024 TR 617, State of Kansas versus Abel Estrada Jr. Paul E. Dean appearing for the state, Mr. Abel Estrada Jr. appearing in person and pro se via Zoom. Now, Mr. Estrada, you were convicted of displaying an illegal license plate. You apparently had a legal plate in your car, but you chose to put on your car a plate that you had ordered specially made from a company, and I can't remember at this point what it said. You didn't like the decision, and
Your Honor, this was the exhibit.
There it is. Thank you. And that was manufactured at your request by a private vendor. And you were found guilty, and you said you were going to appeal. I don't believe you have paid. I don't believe you've posted your appeal bond. Then you filed some motions for today, but the main concern is you need to either pay or appeal, perfect the appeal. And if you don't, I'm going to have to direct the clerk to send in the notice to the state to suspend your license for non-payment. So let's take a look at the file. Okay, I do see something dated 2/19/2025. Appeal, notice of appeal to appellate court, and you filed that notice of appeal. So you started the appeal process, but typically they don't accept those until or unless accompanied by an appeal bond. And you did not pay that cash bond, did you?
No, I didn't. I actually did the properest, and I got a letter from the appellate court, and they said that I needed to be signed. I sent it in, but it needed to be signed, so I submitted, as soon as I got it, I submitted it to your office, and then they told me at your office that you wanted to see me today here about that letter. All I need is to get a signature. I perfected all the paperwork. For some reason, it didn't go, but if I get the signature, then I'm continuing. I'm doing it. I'm doing everything that's supposed to.
Well, I see you filed, one page, it says motion to proceed in form of papyrus. I, Abel Estrada Jr., is disabled and am requesting for a waiver of court fees for the appellate court. Sincerely, Abel Estrada Jr., and it's signed and dated 2/28/25. Well, apparently, Mr. Dean, that's up to the district court to make that determination on an appeal. I would have thought the appellate court would have made that.
That would be my understanding as well. I don't know what letter Mr. Estrada is speaking of. We don't have anything. I don't have anything that shows. I've got the notice of appeal. Mr. Estrada has not been sending copies as would be required to opposing counsel of his filings with the Court of Appeals. We've received nothing. Mr. Estrada, in criminal cases, civil cases, whatever kind of case you're involved in, when you have another side to the case, which is always the case, if you file something, you're supposed to be providing copies to the other side so we know what you're doing. Just as we file a notice or something of that nature, we have to send you a copy. If we file a motion or something else, or they did the initial complaint, you get a copy of it, etc. So I don't know what he's speaking about. I just know that we've had judgment for some time on this case, and let me see.
If I may.
Well, I show the journal entry of trial. Let me see if it was filed February 21st. And that shows that he was found guilty of displaying unlawful tag.
I think he's still within his 60-day docketing time period, so.
I think so too. So, Mr. Estrada, what is it you want to say?
Here's the letter that the appellate court sent me saying that I just needed the, sorry, this one. I just needed the signature on the papyrus, form of papyrus. I don't know if you can see it.
No, we can't. Why don't you read it to us, Mr. Estrada?
Oh, I don't have my glasses. Well, can you read it for me? I have my glasses, I don't have my glasses. Yeah.
Mr. Estrada, the office received on April 2, 25, your certified envelope postmark.
Ma'am, hold on a second. Sorry, could you come more in front of the screen, because we're getting a really I'm at least getting a muffled sound. I can't really tell you.
I can't track it. If you get in front of the camera and tell us your name.
Hi, my name is Annie Estrada.
Anna Estrada?
Annie Estrada.
Annie, A-N-N-I-E?
Yes.
Anna Estrada, and you're the wife of Mr. Abel Estrada Jr.?
Yes.
And you have a document in front of you with the Court of Appeals? Okay. If you'll slowly and loudly articulate that, because it is very muffled for some reason.
Did you want me to read the whole document?
Well, just the
personal part.
Okay.
Body of the letter.
Okay.
Where it says, I'm assuming dear Mr. Abel, and then whatever's below that, or dear Mr. Estrada, excuse me.
Yes, the office received, Mr. Estrada, the office received on April 2, 2025, your certified envelope postmarked March 31st, 2025. You enclose the documents which we have reviewed. At this time, you're unable to docket an appeal based upon the following issue. First, we need either the docketing fee of $155 or a file stamped copy of the signed order of indigence by the district court judge. You have enclosed a motion to proceed in form of papyrus, but no order by the court has been provided. Next, we need either a file stamped copy request for transcript document filed with the district court with service on both the court reporters and opposing counsel, or a statement that no transcripts will be requested with service on the opposing counsel. A request for transcripts must note that it is being made for purposes of an appeal and must comply with rules 2.04 and 3.03. Finally, please be advised that docketing must occur within 60 calendar days of the filing of the notice of appeal with the district court. If this does not happen, then it will also be necessary for you to submit a motion to docket appeal out of time to this office, along with the items noted above. This motion must also be served by you opposing counsel.
Yes.
It appears your deadline for timely docketing would be April 21, 2025. As a result, a motion to docket out of time is not currently required, and we cannot hold the motion you have submitted as it does not serve your opposing party. Only the appellate courts of Kansas. The remaining documents you have submitted will be held by your office on your behalf for a period of 6 months pending receipt of the items noted above. This office is unable to provide legal advice or assistance.
All right, so you have not perfected your appeal. You've merely filed a notice of intent to appeal. Sounds like that's the only thing you have, and that the Court of Appeals is not officially recognized.
Your Honor, it also sounds like the Court of Appeals gave him a checklist of things he needs to accomplish that we're not authorized to advise him how to complete.
Right.
Which I already did.
Clearly you haven't, sir, because the Court of Appeals just told you the list of things they need you to do, including sending a copy and certifying that you provided me a copy of things that you filed with the Court of Appeals. They specifically
Don't interrupt him. Let him finish.
They specifically advised you that you had not. And I have not received anything from you except for this motion to dismiss liability, which, Your Honor, I don't know that I have anything to argue on that other than it's nonsense. I'd ask you to deny it. I mean, it does it. I don't even know what he's attempting to do, whether he's asking the court to reconsider the judgment, doesn't state that, whether he's asking the court to make an indigency finding. He has presented, other than naked statements that he claims he is, has provided nothing to the court to make that consideration, or whether he's asking the court to waive the appeal bond. It doesn't say that either, but those are the three logical conclusions I could come to that he's trying to request. But I don't believe anything's been presented that would give him relief, and that's all I have to say on the topic.
On your motion to dismiss liability, let's take that up. It says, I reserved my right not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly nor voluntarily or intentionally. Furthermore, I do not accept any liability of a compelled benefit of any unrevealed contract of a commercial agreement. And then it's signed Abel Estrada Jr., living man, authorized representative for Abel Estrada, straw man. Now, I'm going to deny that because I share the state's comment or belief that it makes no sense. It doesn't have any legal argument in it. So motion to dismiss liability, whatever in the world that's intended to be, is hereby denied. The journal entry of continuance, did you file that?
I think the journal entry of continuance, Your Honor, may be the last one where we were reviewing the status of the appeal and or the payment of costs and fines.
That's what that was. Okay.
Yeah, the payment of the appeal bond. So I believe that was a late April date on the perfecting the appeal. So I would ask the court to set this over to someday in early May. But it hasn't been properly completed at that point in time. The state would be moving to dismiss the appeal.
If I may, I did submit copies of everything that they asked me to your office. And by the way, the actual April letter that I sent certified, that was the second letter that I sent. I sent it because when we went to court the last time, it didn't seem like you guys got anything, so I resent all the paperwork again for the second time. But all they're asking right now is the papyrus indigents, which you already have, and then the request for the records. I already sent it in, and I sent the COA. So I did the paperwork. It's been sent, and you guys, everybody got a copy of it, or at least at the court of record. That's what they told me. They said, do I need to send one directly myself, or do you get a copy? I'm telling Mr. Dean, the judge and Mr. Dean gets a copy, and they say, no, don't worry, they get a copy. So I submitted that to you guys already.
Okay, when you say I submitted to you guys, who do you mean?
I'm sorry?
Who do you mean when you say I submitted it to you guys?
To the court of record.
Who is the court of record? Is that the district court? Is that the court of appeals? Did you send it to the clerk? You sent it to the judge?
I sent it to you directly, magistrate, and I sent it. I put it on the court of record. So they told me there at the court of record that you're gonna get a copy also. That's why I submitted this already.
I see where I signed off on an order to remove a document from the record that you had apparently misfiled, a motion to docket appeal out of time, and it was premature. You shouldn't have filed that, so that was removed. Missy, didn't you show me that he had brought something into the office, but I'm not seeing it in the file. I don't know what he brought in. Do you have that, or should I have that somewhere? It seems like I saw something that he may have. Missy, are you there?
Yes, I'm here, Judge. I can see there was a paper. Let me go see what it was.
See if it's the clerk's office. But as far as the informal pauperous, I have not made that determination. I did appoint you, perhaps I shouldn't have an attorney, since this isn't or wasn't the level of a jail sentence that would have entitled you to the right of an attorney. And you fired that attorney, and then we appointed another one, and you didn't want to use him. But as I recall, you do have a monthly income. And remind me, does your wife work?
No.
Okay, well, I have never seen, I've never made that determination, and I'm not inclined to make it at this time. You do get some income, as I recall, and if you can afford the transcript to be made in this case, I don't know why you couldn't afford to pay the filing fee.
I'm requesting the papyrus because it'll cover it, and then they told me at the court this morning that when I do the request, that it's not gonna be charged to me. I don't have to pay for the request, and all I need is the letter that I submitted, which is for some reason they're asking for you to sign, so I submitted it to you as soon as I got it.
Your Honor, I would respectfully request the court to the court's denied the motion that was before the court today. Set this matter over to early May. Mr. Estrada wants to argue things, in my opinion, to this court that's claiming conclusory issues that it's been completed, yet the letter that was just read to us specifically contradicted numerous things that he said that he's done and taken care of. I just sent a message to my office to confirm that we've received his copy of the of this motion to dismiss liability. I'll give you one piece of advice. When you're filing something, what the court said is you need to send notice to me. You put a certification here at the bottom saying, listing everybody, whether it's Greenwood County Attorney, the District Magistrate Judge, Webster, and their addresses, and the date you mailed it. That goes here. That's called a certification that you provided notice to the other side so the other side can properly respond. Nothing. I don't even know that you actually know her address in any event. I think Mr. Estrada has a number of issues that he's been specifically told in that letter. that needs to be addressed, and he needs to address them in the fashion that he deems appropriate. And we should review it in May.
All right, Missy, what do we have in May?
We have May 9th. I think that's the only May date we have.
Okay, what time? 11?
11.
All right, I'm going to continue any remaining matters. Well, I'm going to continue the pay or appear to May 11 at 9 a.m. You're either going to have that paid, and cover all of those matters that the appellate court has listed, including paying that appeal bond, also known as a supersedious bond, that needs to be paid of 158 cash.
May I ask a question?
Go ahead.
Yeah, I just need to know if you're going to sign the formal papyrus letter that I sent you.
I'm not signing that at this time.
Well, guys, we've come to the end of this proceeding. And just like I told you guys, Mr. Estrada definitely still has his sovereign citizen head on. And a matter of fact, if you guys haven't seen any of his appearances, his trial, appeal, any of those, we will have links in the description down to those so you can check those out. But yeah, he's still going hard with some of the same lingo. He hasn't paid the appeal bond, which, you know, they keep telling them, listen, you're going to have to pay that appeal bond if you really truly want to appeal this. But, you know, in previous appearances, he said he doesn't have the money. So it's like he's trying to figure out a way to have, you know, that taken care of for him, whether it's through the taxpayers or whether it's through the court waiving it. But, you know, he hasn't provided the prosecutor documents that he's supposed to provide him. You know, the appellate court says he also has a checklist of things that he needs to get done that he hasn't done. And as we can see with prosecutor Paul Dean, if you follow this case, man, he's not too fond of Mr. Estrada. Every chance he gets, man, he takes a shot at him. But I don't know. We see this is just another continuance. I don't know if this guy will be back or not. I mean, at this point, I never like to tell anybody to give up on anything. But at this point, you know, I think they're going to, you know, eventually just deny his appeal, and he's going to end up getting that license suspended for not paying the stuff that he was supposed to pay. And with that being said, before we close out, I must say, Judge Webster, she looks a little different. Her face seems a little smaller. So I don't know if she lost a little bit of weight or what, but her face looks really skinny. She looks a little different, even though, you know, we know her motions of fixing her glasses. I mean, obviously we know it's her, but she definitely looks a little different. So, you know, maybe she ended up losing some weight, has some stuff going on, but good for her. But with that being said, this is Sovereign Citizens Hall of Fame, guys. As always, I appreciate you guys joining me. Don't forget to like, share, and subscribe to the channel. Thank you for all of you guys that's been supporting the channel through Buy Me a Coffee. That has truly been a blessing. And I appreciate any other, donations or sponsorship or whatever else is going to come through that. I want to thank you guys in advance. But with that being said, guys, this is Sovereign Citizens Court. And for now, guys, Sovereign Citizens Court is adjourned. I'll catch you guys on the next proceeding. God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.